Justice from Cook Community Belfast. She will be speaking of systematic barriers to holding police accountable for human rights violations. I welcome you. The second speaker will be Prasad Abhinav Sekhri. Sir is an NSIU graduate who was awarded a prestigious 3 lakh scholarship in 2017. Thereafter, he went on to pursue his LLM from Harvard Law School. Presently, he is practicing as a lawyer in New Delhi and regularly writes about criminal law and procedure in scholarly journals, newspapers, and blogs. He will be deliberating on custodial violence, the need for regulation of substance. I welcome you, sir. Other participants, please note, the floor will be open for the question and answers at the end. Participants can put their questions in the chat box. If the question is directed to a particular speaker, kindly mention the name of the speaker. I now invite our program director, Dr. Prem Kumar Gautam, to introduce the theme of the session.
Okay, shall I start? Okay, thank you, Sakshi. Hello, everyone, and welcome to this webinar on police reform. As we know that the growing number of police and atrocities is going on, and inhuman treatment is also there to the custodial persons, and this raises several issues and several questions on the functioning of the police in India. Though there are several Supreme Courts and High Court judgments, which judgments where courts directed the police to follow the rule of law and do not take the law in hands. But it seems that police is protected under the shadow of the government, and they are capable to justify every encounter and inhuman behavior. If this is true, then how our courts will ensure justice to the poor and sufferer? And this is the question which I think is there in mind of everyone. So for this, finding out the solution of this question, and for further discussion and deliberation, I invite Ms. Devika Prasad and Mr. Abhinav Sekhri to take forward this discussion. Thank you.
Thank you, sir. Without further ado, I invite ma'am to commence the discussion.
Good afternoon. I hope everyone can hear me.
Yes, ma'am.
Okay. I'm Devika, and I represent the Commonwealth Human Rights Initiative, where I've been working on police reform ostensibly for a very long time, and it's a very hard road, a long road, full of frustration more than anything else. So that must be said straight up. Thank you so much to the seminar committee and to the university and to everybody who's involved in organizing this for inviting me. And I'm really looking forward also to hearing Abhinav speak and to interacting with all of you. Now, I myself, it's a little bit, it's intimidating to be in a environment of lawyers. I myself am not a lawyer by training. So in my talk or in my presentation, I'll touch on a few other aspects which are beyond perhaps just the legal, and look at also policing as a system and what are barriers within that actually obstruct, like Sir pointed out, the police upholding the rule of law. So I hope that that'll be interesting for you. And in fact, I was hoping to speak after Abhinav because there might just be a little bit of repetition. So, I mean, if you can forgive us for that, because there are only specific things actually to talk about in many of these issues. Now, I want to actually frame and flag to all of you what I see as barriers that actually hold back accountability of the police. I mean, when we think about custodial violence and when we think about even encounter killings, these do come in the frame not just of illegal action, not just of excessive action, but also human rights violations. So it's criminality which falls into the realm of human rights violations. And why is this happening by law enforcement? Why is it happening by the very authority which is meant to uphold the law and enforce the law. So, I mean, we don't have enough time actually to get into all of the various reasons. And I will also say that this is not a problem which is only at the door of the police. All of this is enabled by a breakdown of, I think a culture of permissibility of the legal system. And I can explain that a little bit and maybe in the conversation. But if we come to the police, and if we look at the blocks to accountability, then I would say that these barriers are of three kinds. They are structural, they are legal, and there is a kind of, a cultural, institutional mode also, which actually prevents accountability. Now, and all of these flow into each other, as it is with any large problem, with any systemic problem. Different aspects always flow into each other, and that's precisely what makes it systemic too, which just makes the difficulties much more. Now, one thing to flag in terms of the makeup of our police, which maybe perhaps for all of you that is a little bit less familiar than legal provisions. One is that there has been no structural reform of the structure of the police in India post-independence. We have inherited a structure which was designed and made, conceived essentially by a colonizing power, and which we've retained. Now, it's much deeper than that, but right now, that's what I can tell you. There have been recommendations for structural reform, but none of those have been heeded. Now, these have implications for the nature of policing as well and the quality of policing. If we just look at data from 2018, and this is official data, which comes from the Ministry of Home Affairs, from the Bureau of Police Research and Development. So it is drawn from police departments themselves. 84% across India, 84% of the police is made up of constables and head constables, who are the junior most rank of the police. 14% are made up of the class of officers who are investigating officers, from assistant sub-inspectors to inspectors. And less than 1%, only 0.87% of our police is made up of senior supervising officers, largely made up of the Indian Police Service, but not all, from the ranks of deputy superintendent to DG of police. So 84% of our police is made up of the lowest rung, the ranks which have the least access to specialized training, the ranks which do not have investigative powers or capacity, who are essentially there to follow orders in terms of law and order duties, perhaps assist in investigation, but that will also be at a very basic level. So, and that is 84% of our police. So, I mean, now I'm not making the argument that somehow we need more IPS. No. But what I'm trying to place before you is that we must really have in our minds, this tells us what are the levels of technical skill, of policing knowledge, of investigative capacity that our police have. Now, these are very live issues. These are real issues which, even in terms of human rights concerns, we can't ignore, though they are not any justification, but we can't ignore them. This also means that, the level of supervision from seniors, because there aren't enough seniors, is also much, much less. And probably, I mean, there's a lot of stress in that too. It probably doesn't happen very much. So, and I'm here now only talking about investigative work. A police has to do much more than investigative work. Especially in a country like ours, which is as complex in its makeup, and the kinds of social problems or divisions, etc., that we may have that may be leading to crime, maybe leading to violent crime. we need a police that can do much more than just have investigative capacity in terms of prevention, engagement with the community in a very democratic way. But none of that is possible because of this pyramid structure, and which we have an absolutely undercapacitated and underskilled police. So now expecting that there is going to be a very nuanced enforcement of law in this situation is something which is not possible in this structure. The other element which is also important, which I hope you'll find ways that this is relevant for you, is that the diversity within the police is minimal. Now, according to figures from 2018, which are the latest, women across across the police in India make up only 9% of the police. There's variations at the state level, but this is scheduled castes make up only 14% of the police. Scheduled tribes make up only 9%. And Muslims as a religious minority, we only have figures from 2013, and that is only at 3%. When this is the minority community in largest numbers. So we have very prominent and also vulnerable communities whose proportionately they are not represented in society as they are in the police. Now, that does mean that we have a police which is not representative of us as a society, and that also does have implications, and it has implications in terms of approach and orientation and perhaps discrimination also within the police. Just to give you a small indication, in terms of the constitutional requirements of reservation, 19 states, again, these are figures from 2018, 19 states in India do not meet their quota in terms of representation of scheduled castes and the standard that we are to reach within the police. 26 states don't meet the quota in terms of scheduled tribes. Only 7 states have more than 10% women in the police. Tamil Nadu is currently at the highest level at about 17%. And all of these questions of representation, it gets worse as you go up the police hierarchy. So as you go up the police hierarchy, where you have positions of leadership, you have positions of decision-making, then the people who are there represent only a very small subset of all of us who make up this country. Of course, there will be variations at local levels and community levels, but this is, by and large, this is the state of affairs. So we have a police which, structurally is really not able, it's not qualitatively up to the mark to be able to do rigorous lawful policing. And we also have a police which is not representative of us entirely as a society and all the different perspectives which we bring in terms of our diversity. So that is one element. Now, in terms of the legal, barriers of holding the police accountable, I'm sure that Abhinav will have much to say in great depth, but much beyond me. I wanted to just flag a few things, which to me are, both practical concerns and deep-seated concerns. Now, we know that Article 22 of the Constitution of India gives every arrested person 3 very crucial rights. 1 being knowing the grounds of arrest, 2, having legal representation, and 3, being produced, the right to be produced before a judicial magistrate within 24 hours. Now, these are also very practical concerns of keeping a person beyond just the legal imperative of the limit on state power, the checks and balances on the police. And these are also these are shields, these are safeguards for every arrested person in terms of not being just at the whims and fancies of the police for too long. I think all of us, I don't have to go over the case law, that the right to a lawyer begins at the moment of arrest. And this is very important. And all of you who are lawyers right now, and many who are, and all of you who are going to go on to be lawyers, I also don't need to go into the sacrosanct nature of um, the, the relationship between a lawyer and a client, and the need for that to be seen as something in which nobody else can interfere. And it has to be given that sanctity of privacy, etc., particularly when a lawyer is conferring with their client. Now, beyond Article 22, Section 41D of the Code of Criminal Procedure lays down that every arrested person can meet an advocate during interrogation, but not throughout interrogation. Now, there are many problems here. And in fact, the letter of the law and the lack of any supporting mechanism, in fact, defeats that constitutional right which is inherent and which, to my mind, is a huge safeguard to prevent torture or custodial violence from taking place in the first place. So the right is there, but can it even be enforced? As we know, there is actually, the right is there, but we know that it is very difficult for a lawyer to meet an arrested person once they are in police custody. If they're able to meet, it might be through the bars of the lockup, where many people will be able to hear the conversation. It will very rarely be in private. And that is the crux of this whole thing, that it actually takes away so much from that safeguard that we don't have mechanisms, practical mechanisms in place to ensure that a lawyer and a client can confer with each other. The lawyer can give advice to that client. We must also understand that lay people in India across classes, across levels of education, do not understand concepts like the right against self-incrimination. They don't know what it means, that I may incriminate myself by saying certain things, or there are ways that I can prevent that. I may incriminate somebody else by mistake, inadvertently. It is exactly in these moments, critical moments of interrogation, that the legal intervention of a lawyer is so important to ensure that these rights are upheld. The right against torture, the right against any kind of coercion, the right against self-incrimination. And it is the right to a lawyer which is the arbiter of that right. But is it even possible? And I mean, we have case law like Nandini, Satpathy, etc., which makes it very clear that the right to a lawyer begins from, in fact, even the moment of, even if you are not arrested, but if you are just being questioned in custody or just questioned. But again, the practical enforcement of that right on the ground, when we look at the balance of power between the police and everybody else, and when we are at the premises of a police station, it becomes very important. Now, this is something which I think makes people very vulnerable to physical coercion, mental coercion, and what can lead to custodial violence. So that is one thing. I think that there are dilemmas implicit in Section 27 of the Indian Evidence Act, which allows for. So while we all know that confessions made to police officers are inadmissible as evidence, the fact of a recovery, and I'm sure Abhinav will be able to say this much better than me, but the fact of a recovery is something which can be entered as evidence, which means that you could have, in some cases, you may have evidence which is born out of techniques which, are third degree, which amount to torture. But because this legal provision allows that evidence to be entered, allows those materials to be entered as evidence, somewhere we need to see, is the law itself giving a pathway for coercive methods? And what can we do about that? And when we see this, then I think we also need to keep in mind that as far back as 1985, the Law Commission of India in its report called Injuries in Police Custody actually made a very, very good suggestion that the Indian Evidence Act must be amended for a new section to be included, which will give courts the power to draw a presumption that any injuries caused to a person while in police custody were caused by the police officers who took them into custody and who were with them in custody. So then the burden of proof shifts, and I mean that's what would happen, and it would be for the police to prove that no, these injuries were not caused by us. This suggestion was made in 1985. It is still lying in cold storage. A suggestion like this would at least mean that we wouldn't have to fight for FIRs to be registered against police officers who are clearly complicit in custodial violence. In the latest case of Jairaj and Benix in Tuticorin district of Tamil Nadu, it took the intervention of the Madurai bench of the Madras High Court for punitive criminal action to be taken against police officers who were, and we were seeing across the nation in newspapers, etc. We knew the injuries that the father and the son were subjected to, and that they were visible injuries. We knew all of that. And still it took this level of intervention for these police officers to be named, taken into custody, an FIR to be registered against the relevant sections, against the appropriate penal sections. Now, all of this is, it does show us a culture of impunity instead of accountability. And I think so that some of these dilemmas implicit in, I know I'm jumping around a little bit, I hope you'll forgive me for that, but some of the dilemmas implicit in retaining in its current form, Section 27, which I believe has been upheld by I think a very large bench of the Supreme Court as being constitutional. That is something which, I mean, there are dilemmas implicit in it. I don't know if I would say that it must be struck off completely, the statute, but certainly I think it needs to be seen in light of what it enables. And of course, I mean, legally, one last thing which really blocks accountability is the retention of Section 197 of the Code of Criminal Procedure, which is the requirement of prior sanction in terms of prosecution of any public servant. And the Supreme Court has laid down that, this section does not mean that it is a blanket sanction. It must be seen case by case. It must focus on protecting judges, police officers, all public servants from so-called vexatious proceedings, but it does not put any official above the law. But in practice, in fact, that is often what happens because sanction is simply not given, or sanction is delayed so much that it becomes a moot point, and we don't move ahead in prosecution. And of course, not taking police officers who may be complicit in these kinds of crimes, the possibility of their tampering with evidence, etc., is also very real. And I mean, it has to be said. So as long as somebody is able to manage situations to their benefit, then that will have real legal implications also. So I think, there are many more legal issues involved here. And I mean, there just isn't enough time. And I don't know if I'm going above my time. But these are some things which, to my mind, would be, very key in terms of these are barriers which actually block us from preventing custodial violence and also holding police officers accountable for custodial violence. And just the last point I wanted to make, which, because I've worked closely with police officers, and I must say that I've had the privilege of working with very, very fine police officers who truly believe in accountability and, are not at all averse to seeing these issues in this way. But I would say that I think that there is absolutely a permissible culture within police departments which does not condemn custodial violence, illegality in the way that it has to. So we don't see very strong messages from police leaders any time that something happens, any time that there is a custodial death, any time that we even hear of a case of, say, illegal arrest. We don't hear condemnation by the higher ups. Often there is perhaps at least a shielding of some. And I think the one major barrier in terms of the policing culture is that there is very little command responsibility. This notion and the legal concept, which is very well entrenched in in the Convention Against Torture, and I think also in humanitarian with the law on war crimes, etc. The notion that senior officers, supervising officers, also are to be held accountable, not only if they, so whether they participated or not, just perhaps either instigating something, encouraging something, giving an order for something, that also makes you liable for the act taking place. And until this is not at all entrenched in practice, we see all the time that the immediate instinct, especially for officers at a senior level, is to give them, simply perhaps transfer them if something happened on their watch. Now, transfer is not a proportionate reaction or punishment to something as serious as even an allegation of a custodial death. And so it is only people at a more junior level who are ever prosecuted if that happens. Again, I'm talking a little bit in generality, but I mean, I just want to sort of paint a picture for you. And this latest case from Tamil Nadu shows us that. And I must say that the latest case from Tamil Nadu in that district is not the first case of very, brutal violence by the police. In 2018, in a spate of public protests, which actually were looking at a factory, the Sterlite factory in the same district, the police, the protest had gone on for 100 days. On the 100th day, the police actually opened fire, and it wasn't just police, it was people in plain clothes also who have not yet been identified. They opened fire on peaceful protesters. These were community level, community people, families most often. This open firing happened. As yet, this happened in May 2018. There is not a single officer who has been even, I think even an FIR has not been registered. A one-person judicial commission has been formed. The CBI has been doing investigation, and the NHRC, the National Human Rights Commission, has also been involved and seized of this matter. And yet, we haven't had any punitive action. So we must ask ourselves, how deep is the impunity which is allowed for our public servants in the face of criminality, in the face of serious misconduct? And then what are all of the enabling factors which actually are perpetuating this? So I think that I hope I haven't gone over my time. So I hope that this gives you a sort of big picture scenario, and this is where I'll stop. Thank you.
Thank you so much, ma'am. I now invite Abhinav sir to continue the discourse.
Hi, am I audible?
Yes, sir.
First of all, thank you so much to Devika for what was a very fascinating discussion. And contrary to her fears, there's not going to be that much of an overlap, even though she's already covered a large chunk of important information and important issues as far as even the legal arena is concerned. But that I'm just going over my notes again to make sure that my claims are not bogus. But I don't think that there's going to be too much of an overlap. So let's see. First of all, so I had the I don't know, I had the overconfidence to give out a topic, and the idea was regulation of substance. And the reason for that was, one is basically to show that what we do right now, as far as legal regulation is concerned, is the regulation is mostly focused on procedural aspects. So and Devika pointed to Article 22 of the Constitution. She pointed to Section 27 and 25 of the Indian Evidence Act. She also pointed to Section 197 of the CRPC, which works in the reverse way. But nevertheless, the main space of fight, as far as this field is concerned, ends up being spaces on procedure. So that's one thing that I'd like to focus on through the conversation now. And the other is, just by saying regulation of substance, what I mean to say is that we need to talk about regulation that has more of an impact, that is of substance. Like it matters more. It gets more to do something about the problem, because as we'll hopefully be able to cover during my time, we've been stuck with these regulatory approaches for a long period of time, and these have been with us since the first codes came in around 1860. Our predominant regulatory approach has not changed since then. That clearly has not worked very well. So maybe it's time that, while we still take our effort in good measure to try and rework that approach, it doesn't mean that we don't start doing something about the other areas in which a lot can be done. So without further ado, I'm going to just get into the thick of it. First of all, a caveat. So unlike uh, Devika's presentation, I'm going to largely be focusing on the investigation part of the police work, which is not at all that the police does. In fact, as Devika very rightly pointed out, it is constitutes a meager portion of what is police work in India. But still, that ends up being the focus of my conversation today. Now, the existing approach that I was referring to, what we can do is, actually we can trace it back all the way to 1860 and 1861, when we get the first codes. Now, there are two sets of approaches that the first codes step on. First is obviously a procedural approach, which we see in what was earlier only a procedure code. The Evidence Act comes in later. And through that procedure code, we have provisions that are providing for no confessions to police. Statements to police are not going to be tendered as evidence. There are specific provisions that say that any statement taken upon promises, etc., is not going to be valid. Now, all of that is in recognition of what seems to be the reality at that point in time, that the police in different parts of what was British India were notorious in going ahead and taking confessions and taking statements and launching cases purely on the basis of those. So all of this was intended to provide some safety to persons who end up being arraigned in criminal cases. But at the same time, there was also a crime that was created for any person, not only a police officer, but any person who ends up going down this road. So we have, and we still have them, sections 330 and 331 of the IPC, which you may refer to whenever you have the time. Now, what we had, therefore, was an approach that said, okay, if I am the accused, then I am protected from, going ahead and making a statement. And even if I am a person like a witness, I can't be compelled to give a signed statement. The logic is, since it's not going to be used in court, the police are not really going to have incentives to use it. At the same time, you have legal provisions that criminalize police officers going ahead and engaging in any of this conduct. And so you hope that that's going to deter them. Come 1901, when there is an audit of sorts of how police have been functioning, it becomes very evident that these approaches have not really done anything. One key reason why the procedural approach failed is something that Devika has already mentioned, which is Section 27 of what came as the Indian Evidence Act in 1872, which says that even though confessions or statements to police by accused persons are not admissible, if they do lead to a discovery of fact, which very commonly in any cases that you refer to will be discovery of gold bangles in a murder case from the body of the deceased. Now that means that you can even use the portion of the statement itself as evidence. What that meant even in 1901 and continues to mean today is that police have an incentive to get you to say something because it is not fully inadmissible. Not only do they have an incentive to get you to say something, all they need to do to make it admissible is to just show a recovery. And so the Indian Police Commission at that stage itself cautioned against what was proving to be a failing strategy. It also cautioned as to what was the glaring absence of prosecutions under section 330 or 331. If, and this is something that I ended up doing for a paper, if you go ahead and search from 1860 to let's say 1947, the number of prosecutions that you will find under sections 330 and 331 from whatever database that you might refer to are going to be less than 40. And admittedly, there are limited reported judgments available for that period of time. But still, considering the total number of criminal cases that you will find and the number of cases in which confessions are used as evidence, it is a minuscule proportion. And the number of successful prosecutions is even lower. So pre-independence, at least, even in 1947, not much has changed as far as our approach is concerned. Devika's already again mentioned that we have not dismantled what was a colonial system of police administration, nor did we dismantle what was a colonial approach to regulating police violence. In fact, the issues as far as police administration only worsened. And the numbers that Devika provided for what is the police force across various states in India today, where investigating cadre of officers make up for a very insignificant proportion. It was also true in the years immediately after independence. Now, what I'd require everyone is to just think about the position that a state or a governance system finds itself in when that happens. You have a body of law that says, and that is largely premised upon protecting an accused as a source of information by providing a legal protection against the use of their statements. But at the same time, you have a police that is not really doing its work as well as it could because it is understaffed, under-resourced, underfunded. What then can happen is that the accused was and continues to be the main source of information for an officer who is hard pressed to show results. Now, when this issue ends up in court, there are two ways in which this can go. Either a court is going to double down on the regulatory procedures that are there and say, no, there is no way that I am going to allow you to use these statements. Or the court is going to put on its strict scrutiny hat whenever it sees a statement and whenever it sees a recovery pursuant to a statement. And then the court is going to go, okay, no, wait, there seems to be something clearly wrong here, and therefore discard the evidence and possibly lead to an acquittal. Or a court is going to think about rights and think about ways in which exceptions ought to be carved out to safeguard investigations. And since independence, more or less the trajectory across high courts as well as the Supreme Court, and I'll come to the Supreme Court in just a minute, the trajectory has been to adopt the latter course, to basically have procedural rights as something that is very good, but that is always going to be subject to the odd exception to make sure that the interest of an investigation is not completely lost. What ends up is basically in 2020, our rights are much more like cheddar cheese, where you look at it, the holes are more prominent as far as the appearance is concerned than the substance itself. And again, there is too little time to give a full conspectus of how this happens. But the focus that I think I'd like to use, because I think it again goes to the heart of the matter, is how courts in India have viewed the idea of police custody itself. And when I say police custody, I mean the lockup that Devika again mentioned. That place in the police station where I will be kept after arrest, that the police will struggle to keep me for about 7 to 14 days, depending upon the kind of offense. And that is something that I think we really need to look at carefully when we look at how courts in India have dealt with police violence. From the 11 judge bench decision in Kati Kalu Ogad, which was a decision that concerned the scope and ambit of what is the right to silence in India under Article 20, subclause 3, the court had at the heart of that case a simple question. If a statement is made or if anything is done in police custody, should I presume that to be under coercion? Again, something that we saw in terms of the 1985 suggestions. That issue had actually come up before the Supreme Court in January of 1961 because a Bombay trial court had actually held this. Kathikalu Ogad was forced to give handwriting samples whilst in police custody, and the trial court said that, look, I am going to assume that this was coerced, and therefore those handwriting samples are not admissible in evidence. The Supreme Court said no. In a judgment that makes repeated references to the need to safeguard the interests of an investigation, the court on this core issue says that, look, mere questioning in police custody can't be assumed to be under duress. And therefore, if you are asking a person some questions and if a person responds, then there is no problem with it. The problem obviously was, in reality, there is no such thing as mere questioning. If I am in a lockup, totally subject to the police, in a system where I do not have any right to counsel, in a system where the police till 2008 did not even have a clear statutory duty to inform persons about my arrest. It is never mere questioning, is it? But unfortunately, that was the road that was taken, and that was the road that we continue to travel upon. So much so that in 1998, in a different decision, the Supreme Court actually said that, look, we have to acknowledge that custodial interrogation it has its own merits, it has its own unique benefits. And therefore, the court said that, look, you can't say that there's nothing to be gained by keeping a person under arrest and questioning them, because often it leads to more results. So from a position where we think that, okay, there are procedural safeguards to protect the accused as a source of information, you have courts that are repeatedly telling us that, well, all of that is good, but we need to balance that with the interests of an investigation. And we are not going to be oblivious to the fact that the accused is a great source of information. What that leads to is a dissonance. You cannot be in a position where those small, minuscule acts of violence that are committed every day in police custody, during police questioning, either by keeping a person under lights for 12 hours, or by questioning them through the night, or by not allowing them food or water for extended periods of time. And obviously, then there are more mundane, brutal forms of violence that we are very familiar with, that are often even lionized in popular media. You can't disassociate those with what are the most extreme and visible examples of police violence, which happen when an encounter takes place, or when there are innocents to the extent of not having committed any crime that requires vengeful retribution, who end up being murdered at the hands of police officers, obviously subject to a trial. I'm saying that today, as far as procedural norms are concerned and that regulatory approach is concerned, that dissonance goes to the very heart of how we view custodial violence. Until those minuscule acts of violence are targeted as being a problem, and there are various ways in which the problem can be solved. One already has been mentioned at length by Devika, which is to really empower Article 22 to provide realistically for a right to counsel. But keeping that aside, until we even acknowledge that that is a problem, there is a long, long road to acknowledging the most grisly forms of that violence. That chapter is something that I think that we really need to reckon with. Hopefully, the reckoning will be soon and within our lifetimes, and it won't take 150 years more. But at the same time, that is a pressing reason why we at the same time can't just be banging the drums of again and again how great this procedural system is that protects accused persons. Not only is it insufficient in and of itself as a means to protect accused persons, it is evident to any keen observer, even a lay person, that it is not sufficient to regulate police violence. Therefore, the need is to return the gaze to what is a regulation of substance. How many of us are frankly aware of court decisions that are telling us, okay, what are the lengths of, or what are the bright lines regulating police conduct? So again, all that I said, is it legal for the police to keep someone under questioning for 12 hours? Is it legal for them to just slap around a person or to deny them some water or food? To come to more substantive questions, when the police are exercising brutal force, or they're exercising force while effecting arrest, what are the bounds of that arrest? Again, all of these provisions are present in the CRPC, but their contours are not really well established. Further, what about sections 330 and 331 of the IPC? How many prosecutions happen year on year for police violence, and how many of them are successful? And lastly, what about compensation? The jurisprudence on compensation itself is hardly around 3 decades old. It still does not have a clear statutory footing. It still requires aggrieved accused persons to knock at the doors of high courts, which is not going to be possible in every case, hardly every case. Barely a few cases will it be possible. So what about creating a system that, if the police are not accountable by way of the criminal procedure itself, what about monetary compensation? What about fines? How does that setup not formally exist till date in a country that not only publicly acknowledges its violent police, but also has a judiciary that has offhand, on record, and in lengthy, copious judgments repeatedly told us that, look, the police end up sometimes going too far. So I think it's high time that the lens, while the procedural safeguards are existing, they're there, they can be looked at, and they are being looked at every day, and they end up being the focus of a lot of conversation. I think at the same time, it's time that we talk about the regulation of substance, of substantive law. Maybe we need to look at the offenses that are already there as far as sections 330 and 331, and maybe re-energize them or look at them and figure out why prosecutions don't happen. Maybe it's also time to start thinking about how can we get easier ways in which persons who are aggrieved can get redressal. At the end of the day, my interest to pay for my medical bills is going to be as high as my interest to see justice be done by way of a successful prosecution. But again, only one of those interests has hardly been thought of, and one of those, nothing has been done about it. I think with that, also my time is almost up. So I think with that, I'm going to close whatever I had to say. And I think we, subject to everyone's convenience, could possibly open the floor for discussions. Thank you.
Yes, sir. Thank you so much. Participants, the floor is now open for the questions and answers. You can put up the questions in the chat box.
Is it going to come up in the box on the screen? Is that how it will work?
Yes, sir.
Okay.
The chat box itself. Sir, by the time I have a question to you, sir.
Yeah.
So you suggest that we need today regulatory changes in substantial form for the prevention of custodial violence. So my question is how far the judiciary can play a role in that process? Because it's been a long time and there's no change in the law as well and the regulatory framework. So how far judiciary can play a role in this mechanism?
I think there are a number of ways in which the judiciary can start and is already doing a lot to try and provide its and rather fulfill its role as checking upon executive, let's say, over exuberance. One is obviously, and the most important being magistrates and them discharging their everyday duties, because at the end of the day it is the magistrate who is the person, as far as the judiciary is concerned, who is directly looking at what the police are doing in not only specific cases but also by virtue of the magistrate's position she can see larger trends appear as far as, let's say, arrests are concerned or requests for searches are concerned. So not only a an approach as far as, okay, looking at each specific case about, okay, so there is a person in front of me as far as custody is concerned, then thoroughly interrogating, okay, what is the requirement for keeping that person in custody and what has been the investigation so far. But besides that, maybe also taking a larger lens to look at, okay, well, are there trends that I can see as far as, in my area or in my small district? Because magistrates, I mean, subject to where you are in the country, there are usually frequent transfers that happen on a fortnightly or a monthly basis, that a magistrate in one district will be sent to another. Depending on how big the area is, those transfers will be less infrequent. But someone who has, some time, even a month, can show you many trends as far as arrests and custody requests are concerned. So those are just some suggestions.
Thank you, sir. So we have now questions in the chat box.
I'm just reading. Sorry.
Yes, sir. Ma'am, you're not audible. I hope that is your on mute.
Can you
Excuse
hear me now?
Yes, ma'am, you're audible.
Someone's trying to say something.
excuse me, I have a question. Don't you think the glamorization of the police investigation by the Bollywood ha has played has had an irreversible effect on the society as a whole? That it is not now it is normal for the police to get answers from the accused, to investigate the accused, as has been depicted in movies like Singham, Dabang and all that. So won't it be more important to change the mindset of the society at the initial stage than to approach the judiciary, or look for strength to strengthen the laws, more laws? What, uh, we need to change the mindset of the society first, isn't it so?
Abhinav, do you want to
No, why don't you go ahead
respond?
first, Devika, because I think it first rings
Okay.
home with a lot of the themes that you touched upon.
So on this question of, I don't think it's so much the glorification of investigation, but it's in fact the glorification of the use of violence. And it's the glorification of what you can even call torture. And certainly excess force, which you're very right is a continuing theme in Bollywood. And I think that it's very right to point to how this gives a legitimacy and a sort of, to these actions by the police, and also a lack of questioning of whether some the questions that Abhinav pointed to, that can the police even slap you? So we need to ask ourselves, can the police even slap you? Here there are questions of, can the police beat you black and blue or perhaps even kill you if you are even a so-called dreaded criminal? So these very easy tropes of, criminal, all of this comes from popular culture. And you're right that I think it is very damaging, because it is not enabling us as a society to, one, condemn police violence on principle. We're selective in what we condemn. And that is, until that changes, we're not going to have a balanced and informed, really, public debate even on these issues. So, I mean, a set of colleagues from another organization recently wrote a very compelling article, And in it, they said, they pointed to the celebration of the encounter of the accused in the Hyderabad case of gang rape of, she was a nurse. I'm sorry, I can't remember her profession, but that the celebration of that encounter next to the condemnation, the absolute outrage of the killing of Jairaj and Benix in the custody of in the Santakulam police station in Tamil Nadu. Now, actually these two police actions, they are the same in the sense that they were illegal, they were absolutely brutal and violent and arbitrary, but yet one is glorified because it is related to some kind of saving of something, and and then the other one is there's an outrage because we feel, oh, these were innocent people who were who were subjected to so much violence. I mean, if Jairaj and Benix were a different kind of accused, would there be so much outrage? Perhaps not. And I think that's something that we have to really consider. And it actually takes us away from a very objective legal discussion, because it takes us away from what are the checks and balances that are necessary for a kind of a more regulated culture of law that Abhinav is talking about. We're not going to be able to have those questions while these notions of who is criminal and on some kinds of people a certain kind of action can be taken and must be taken, but on others, no. We can't have it. It is actually this or that in these questions, especially when it comes to the protection of life. And I think we don't ask, as a society, we don't ask enough questions of one big part of policing must be to actually safeguard life, whosever life it is. Whether somebody who's traveling, who's in transit in custody, it is the police's responsibility to ensure that they come out of that alive and well. And the excuse that perhaps somebody should have been encountered, I mean, it really shows us where we are in terms of our own public debate. And I think then it'll be harder for us to have the kinds of public conversations to support the technical debates that would be required in terms of what Abhinav and to an extent I pointed to in both our talks. So yeah, and I do feel that courts are also somewhere, I can't put my finger on it, I'm not saying it as evidence, but I think courts are influenced by all of this public, what goes on in the public consciousness. I'm not going to say in what directions I think the influence are there, but certainly the fact that we do have a celebration of police violence also is something which will affect all of these core questions.
We have questions in the
Yeah.
chat box. Is it visible?
Yeah, I have noted all of them down in the meanwhile. So, first of all, so on Ravi Shankar Pandey's question, I think it doesn't. So he's asked me about a paper on police, on pendency in the criminal justice system and the impact of police. I think it's best if you contact me separately if you have to discuss that, because it doesn't fit in the theme here. So I'm just going to flag that, and you can please feel free to reach me on that. And there is a question from Rakshit Bajpai about reforms to increase efficiency in the institutions and what can the government or judiciary do. Frankly, I think the judiciary is best not to do anything about any of this and just dispense the massive caseload that it already has. As far as the government is concerned, I think a lot, as far as efficiency goes, I think that efficiency question can't be divorced from funding and resources. If you look at budgets and if you look at, again, the if 84% of constables and head constables is what the police force is, please take a hard look at exactly how much they earn. Please take a hard look at what are their employment benefits, and then see what, and what efficiency do we expect from this setup. There are there are there are a numerous, I mean, actually they're not that many, and Devika will be able to point to them more than I'll But there are studies out there that are documenting the police as a system, as an organizational system, which is something that is often lost in conversation. The police is a bureaucracy. You are asking for efficiency without appreciating all of that, and that is what I feel sometimes public conversation forgets, that unless we get all of the other angles as well, it's not going to miraculously figure itself out. So I think it's not, again, a really hard sell to figure out what can we do to improve the police. A lot of very simple things are out there and very low hanging fruit that can be grasped. But I'll just leave it at that for Devika to substantiate it. Just another thing that Rakshit had asked: what about an all India authority for complaints? I think that's not a great idea, largely because, again, as he himself points out in his question, policing is a state subject. States in India are vastly diverse. They are vastly diverse not only in terms of their makeup, but also in terms of their police. And at best, an all India authority can definitely look at how different states have responded in terms of data and to show, okay, what are best practices. But to regulate on top of state authorities, I am not sure about how that would go. Uh, yeah, so those are the specific questions that were addressed to me. Devika, would you want to talk a little more about increasing efficiency in the police institutional setup? Because I think you'll have a lot to say about it.
Yeah, actually, that I think requires uh, another session. I mean, very fast, just, it's interesting because the parallels between, I was in all of what is going on in America with, the defunding of the police, etc. Colleagues and I have been thinking about, my gosh, I mean, here we're just at a level where, like, police really actually also need money,
Yeah.
because budgets are so low, and budgets largely, I mean, the less than, it's usually a proportion of about 5% of a state's budget, which even goes to the police. Most of the money which is spent is spent on salaries, and very much little else. And also, for instance, on training, it's between 1 to 2% of police budgets which are actually spent on training. And that's a consistent pattern across decades. So there does need to be really a very evidence-based, I think, academic, rigorous look at this whole question of funding to the police. And I mean, and certainly lawyers and, human rights people like us are not the best place to actually really do it. We need economists, we need people who know budgets, etc., to really look at those questions. So we need a interdisciplinary effort. Um, so, but absolutely, our police is poorly funded, and that is something which it certainly needs much more attention than it gets. On this question of complaints authorities now. So the Supreme Court in 2006 in the Prakash Singh judgment did order that these, complaints authorities are to be set up at the state and district level. That has been very, very poorly implemented, and I won't get into the details of that, but most of where it is functioning, the design of those bodies don't even fit the basic requirements that the court laid down in its own judgment. So, and that has to do with powers, composition, selection of people, and as someone points to, the decision, the extent of decisions. So that is, and we have some, if people want more information on that, please do get in touch, because we have quite a lot of information on that. Now, in terms of an overarching body, one thing I will say is that the National Human Rights Commission it's a quasi-judicial body, as it should be. It shouldn't take over the powers of a court. But the National Human Rights Commission is a body which has powers quite extensive to actually to look into and inquire into complaints of human rights violations, which cover the full gamut of custodial death, encounter killing, extrajudicial killing, illegal arrest. I mean, so we do in fact have a body which can look into human rights violations by the police, which cover a broad spectrum of acts, including torture. So it's not that we don't, but I mean, there are many problems with the NHRC as well. But I mean, we should just keep in mind that there is one forum. And if it exercised the powers that it has in the way that it could certainly, compile prima facie, preliminary, very strong findings on misconduct, etc. So that is one thing. So it's not that we don't need to go down the road of an all India police complaints authority. But there is, of course, in different countries, they've set up dedicated complaints bodies just looking at complaints against the police. And that's what these PCAs in the Prakash Singh judgment, I think, was supposed to be sort of our experiment in that for the first time. And it's not gone well. But it is true that in addition to national human rights institutions, there are many places, including South Africa, Northern Ireland, all of these, which have come out of reform efforts of extensive transformation of policing, which have set up dedicated police complaints beyond authority. I mean, they're quite strong bodies. One body in Australia, the Police Integrity Commission, even has the powers to conduct surveillance of police officers. And, to try to see what is going on in terms of illegality, etc. So there are some very strong bodies like this, which are not courts, but which have, in these systems, they give their findings to the prosecution. And of course, in our context, one major thing that I think, both Abhinav and I will probably be thinking, but we haven't said, is that the investigation and prosecuting authorities are still not distinct from each other. So that's also another problem why they basically function almost together. And there isn't that check either, legally, even in terms of just, are you moving in a direction which is legally tenable by the prosecution throughout the duration of investigation? And that's another check which is completely missing on the police. So I hope this answers these questions. And there was a question on the torture.
So actually, there are a number of them. So I'm just going to flag them for you.
Okay.
I think they'll be up your alley. So Umang Banodia has asked about the status of the Prevention of Torture Bill. And we have a question specifically and more detailed upon that. That is again by, I believe, Rakshit Bajpai. And that's the last question, which is regarding the Custodial Torture Bill Prevention of Torture Bill 2017, and what about it being contrary to other Law Commission recommendations regarding the death penalty. So because it suggested for death as a sentence for custodial death.
Yeah. Okay, very quickly, in terms of, I think everybody is familiar with the UN Convention Against Torture, which India signed in 1997. So we're a signatory, but we haven't yet ratified it all these years down the line, which means that we haven't passed enabling legislation domestically for us to actually enjoy the rights and provisions of that convention coming into force into law in India. Now, and this is, I think this is a sign of the absolute refusal of and the lack of political will to actually take on the issue of torture prohibition in very tangible ways, and not just, kind of stray comments at international forum that India has a very robust regulatory framework which will prevent torture, which Abhinav has, already half decimated in 15-20 minutes alone. So now, so 97 we signed, Government of India signed, no movement at all on ratification. In 2010, there was some movement when Congress was the ruling party, and Mr. Chidambaram was the Home Minister at the time, and in fact drafted a Prevention of Torture Bill, which many prominent human rights lawyers coined the Promotion of Torture Bill, because it was, I mean, truly, it was really terrible in the sense that it did not at all give any deterrence or provide accountability for torture, acts amounting to torture. That bill was referred to, it was passed by the Lok Sabha. At the Rajya Sabha, it was referred to a select committee. And that select committee, and many of us were involved in advocacy on ensuring that that select committee held a wide wide process of public consultation on that bill. And it did happen. And the select committee did come out with it rewrote the government's bill. Its bill has never been tabled in parliament. And in fact, it's pretty much, I mean, it has to be revived in a sense. So we do have that one very good example of a legal model. It's still not fully compliant with the convention, but it is much closer than anything else. And in 2017, so Ashwini Kumar, there was a petition in the Supreme Court which again called for ratification. That was dismissed on grounds that this is in the purview of Parliament and not in the purview of the judiciary, which I suppose legally is also, that is not inaccurate. So I haven't read the judgment in full to see if there were any, I mean, was there anything else which is not being said? But the Law Commission of India, which I think Rakshit is referring to, the Law Commission of India, though, was asked by government to draft a new prevention of torture bill, which it did in 2017. And unfortunately, that bill also is not compliant with the convention, with CAT. It goes backwards and regresses from the Select Committee's 2010 bill. So, institutions are not keeping up with gains made in the past. And so we we regress instead of move forward even further, which is a real problem. I can give, I mean, we did some, we've done an analysis of that bill also against, and I'm happy to send that to everybody, it just as a sort of, just to have a sense of how it doesn't comply with the, with CAT. But there are huge problems both in terms of the definition which is laid down and things which are omitted. And those things which are omitted will always be on liability, command responsibility, so the liability of superior officers. There's often this, in these drafts on prevention of torture, they've always put in a limitation in terms of how far, so if a complaint is filed, it can only be acted on within a year. And after that, there's no limitation in terms of serious crimes in the legal system. So why is there a limitation imposed on acts of torture, complaints of torture by public servants? So, this is the wheel that keeps turning. And I'm happy to share that draft. Rakshit, so there's no question of anticipatory bail. I don't know if you, and also the question of sanction, prior sanction, that is consistently maintained in draft torture prevention bills, which again tells us is government and institutions drafting these bills, they are actually then admitting that perhaps torture is something which sometimes in official duty is required. So yeah, we do need to look at whether someone can be prosecuted when it should just be an open door to prosecution simply at the stage of allegation. So, there are lots of, Abhinav is laughing. I don't know whether to laugh or cry.
No, I was laughing because it's going to take too long to fully unpack these. But there are two other questions, and I see a further question by Rakshit, which I am exercising the discretion to not take up because it's been addressed to me. So you can reach me separately. But there's a question by Niharika about the judiciary and what it can do to ensure safety. I think that was something that again we already discussed, and that was something that at the start Sakshi asked. So that again gets done. Yaqub has asked a question about elected representatives. So his question is about how the colonial system and it is subjected basically the police to the control of a political executive. So but on the other hand, we can't have a police without the control of an elected representative. So again, at least my take on this, and Devika will again have a lot to say about it because of her depth of work in the field. But no one's arguing for a complete free hand to whatever the police does or whatever they do. The only issue is operational autonomy. And today, if, for instance, an elected member of whatever, a political representative has a role in terms of literally what investigations get taken up, that is a problem. That doesn't mean that the elected representative has no role as far as accountability of police is concerned, as to how they are spending their resources and what are they getting as far as work is concerned. But it doesn't at all mean that when anyone argues for change or going away from what is admittedly a colonial setup, that it means that whoever is arguing for that is arguing for no control of elected representatives. And I think Devika will also be of the same bent. That is your position, that there shouldn't be any control by elected representatives? I would argue.
No. I mean, I actually, you've actually summarized
Okay,
huge
great.
amounts of scholarship on this issue. So that's, your instinct is, I mean, it's absolutely right. And now in a democracy, you cannot have, see, I think it's also this usage of the word control. We have to stop using the word control. There has to be political oversight of the police by the political executive. There has to be oversight of the police by the legislature. There has to be oversight of the police by the judiciary, by the bar also in its own way. So in a democracy, all of this is actually multi-level, right? So we will never say that, yes, you can function on your own. It's actually just about defining the roles and responsibilities of the executive, which you can actually do quite easily in law. So like Abhinav points to, there should be no interference in adjudication of criminal cases, on decision-making, on action of any kind by the executive. That should be in the realm of the judiciary. And relevant oversight institutions like perhaps the National Human Rights Commission in certain aspects, but and this can easily be legislated. We have even put in force, we've even drafted provisions. Countries like South Africa, etc., have very clear provisions in their police legislation which demarcate the role of the executive and the role of the police when it comes to decisions around police administration and police functioning. What is in the realm of the executive and what is not in the realm of the executive can easily be laid down. Other countries have actually set up what are called essentially buffer bodies, which have different names, but which lay down, like you pointed to, Abhinav, what is the role of the executive in resourcing the police, in selection, perhaps, of leadership, through a process of consultation is what you would want. It shouldn't be a unilateral decision. But after all, an appointing authority, ultimately the decision of who will be the Director General of Police of a state, ultimately the authority has to be taken by the police leadership. But what we would want is some kind of safeguard or shortlisting, which makes it so that the decision isn't just of the political executive alone, but that it comes with consultation from some other body or some other authority as well. In England, for example, the head of police forces is not appointed within the police, but by a body outside, which is outside government, which is an independent body. Now I think it's actually a one-person authority, which I don't agree with. But so there are innovations in all of this. So, resourcing of the police, even, for instance, patterns of behavior, lots of things can be done which can actually have a good impact on policing. But don't interfere with the investigative function or the decisions on who to arrest, etc. So the political executive has a large role to play. It just needs to be circumscribed. That's all.
Sakshi, is it okay if we call
Yes.
it an end now? Because I think there'll be a lot of questions.
No, sir, all the questions are done. Only one question is missed out. If you
Okay.
would like to answer that.
So again, Rakshit is asked. So I mean, I appreciate Rakshit's participation, but I think I'm going to take up Aniket's question, which is, do mere addition of laws improve the situation, or we need to strengthen old laws first? I think the answer is both. There's no question about it being one or the other. And again, I think Rakshit's questions will take some unpacking. So if it's okay, Rakshit, you could probably just reach out to us. I'm sorry, I'm actually the one hard pressed for time. So I hope that you'd understand.
Yes,
So
sir.
he said no problem. Great.
Off the hook.
Thank you, sir. Thank you, ma'am. Ma'am rightly pointed out the legal dilemmas which perpetuate the culture of impunity to police officers and the enabling factors that have been deep-seated since the colonial rule. Also, it's highlighted the existing procedural safeguards to violence and for the suggested substantial regulatory changes by pointing out the nuances of custodial investigation. I thank the speakers, our program director, and all the participants for joining us for the session today. Have a good day, everyone.
Thank
Thank
you.
you.
Thank you.
Thank you. Bye, everyone.
Bye. Bye, Abhinav.
Bye, man.